Those arrested, charged and tried in the murder case of a boda rider Tamale Aloysius alias Yangamulo and John Bosco Mugisha, the 12 been facing trial before High Court Criminal Division in Kampala, presided over by Judge Alex Ajij.
Mugisha John Bosco, alias Kaihura, and then the other one is Tamale Aloysius alias Yangamulo. I request Tamale to remove the colorful goggles. I don't know whether they are goggles or they are. This cosmetic. They are not eye defect for eye defect. The glasses. Yes. Let your face be seen properly. So the accused persons were charged with 2 counts. One of aggravated robbery and the other of murder. Contrary sections 285 and 286(2) of the Penal Code Act for aggravated robbery and 188 and 189 of the Penal Code Act for murder. The particulars of the offense in count 1 are that Mugisha John Bosco alias Kaihura and Tamale Aloysius alias Yangamulo and others still at large on the 29th of May 2019 at Kanisa Zone, back in the division. He robbed an unidentified man of his motorcycle number UEM 432N UEM 432N and N. The Bajaj Boxer red in color. And immediately after the said robbery, you used a deadly weapon to hit a half block, concrete block, on the said unidentified deceased person. Well, the particulars of count 2, the offense of murder, are that you, Mugisha John Bosco, and Tamale Aloysius, on the 29th of May 2019 at Kanisa Zone, Makina Division, Kampala District, you murdered an unidentified man, contrary to section 188 and 189 of the Penal Code Act. Happiness Ainebiona, Chief Senator, represented the state. While Kumbuga Richard represented the accused persons. Right now, Happiness is not there. But the team of state attorneys is here representing Happiness to receive the judgment. Burden and standard of proof. Before I say that, both counsel put in submissions which I have considered in the evaluation of this evidence. The burden of proof squarely lies with the prosecution. It's the prosecution's duty to prove each ingredient of the offense, and this burden does not shift the accused persons unless there's a specific statutory provision to the contrary. We always refer to the case of Wilmington versus the DPP, and also the case of Okethi Okale and others versus the Republic. This case does not involve a shift of the burden of proof to the accused persons to prove their innocence. The standard of proof is beyond reasonable doubt. All essential ingredients of the offense must be established to this standard, which does not require absolute certainty, but rather a high degree of probability. As was stated by Lord Denning in Miller versus Minister of Pensions.
Introducing WD Ushers, your premier ushering service for all occasions. From introductions to weddings, birthday parties to graduations, bridal and baby showers, handovers, concerts, vigils and burial ceremonies, we've got you covered. Trust us to make your event unforgettable. Contact us on 0772 411 662 or WhatsApp us on 0705 572 794. WD Ushers, elegance in every step.
So the degree of beyond reasonable doubt is well settled. Evidence must be evaluated as a whole. The court must consider the evidence presented by both the prosecution and the defense in relation to each ingredient before reaching a conclusion. The prosecution's evidence should not be viewed in isolation from the defense's evidence. In Abdu Ngobi versus Uganda, the Supreme Court emphasized the need to weigh the evidence from both sides before making a final decision. At this stage, I must determine whether the prosecution has presented sufficient evidence to prove each ingredient of the offense of robbery and also of murder beyond reasonable doubt. For the accused to be required to defend himself, the prosecution must have adduced evidence of such quality or standard regarding each of the following essential agreements as laid down in Uganda versus Waisa Henry and two others. So in the case of robbery, they must prove that there was theft of property. There was use of actual violence at, before, or after the theft. Or that the accused caused grievous harm to the complainant. Prosecution must prove that the assailants were armed with a deadly weapon before, during, or after the theft. And they must also prove that the accused participated in the robbery. The court must consider both the prosecution and defense evidence to ascertain whether the prosecution has met its burden regarding all the ingredients. I shall now analyze the evidence relative to each ingredient of this offense. The first ingredient of theft was theft of property. This first ingredient requires proof of the fact that property belonging to the complainant was stolen. There must be proof of what amounts to, in law, to an asportation or carrying away of property of another without his or her consent. PW1 testified that the property alleged to be stolen, in this case, was a motorcycle, registration number UEM 432N, a boxer, red in color.
Nti omujulizi asooka mu musango guno yagamba nti waliba boda eri namba
UEM 432N.
Nyasa 22 nena era nga yali bajaji boxer nga yali mkirugavu.
The defense does not refute this element.
Nti era temukigaana kino.
Therefore, this ingredient has been proved beyond reasonable doubt that indeed property belonging to the accused, to the deceased, was stolen. Ingredient number 2, use of violence or threat to use violence. As to the question of use of violence, the prosecution was further required to prove that during the commission of the theft, the assailants used or threatened to use violence. And for this ingredient, there must be proof of use of some force to overcome the actual or perceived resistance from the victim. In the proof of this element, the court relied on evidence of PW3 Kalanga Nasula, Detective AIP Kalanga Nasula, who said that on reaching Kanisa zone, the two showed him the exact place where the boda stopped, near a certain gate. And when they... Sorry. Thank you.
Today, court has found the two guilty on all counts of murder and aggravated robbery. Court found them guilty basing on a CCTV camera footage that captured the two murdering Derrick Muwonge by striking him on the head with a concrete block.
And Mugisha got hold of the rider by the neck, pulled him down and hit him with a 9-9 block on the head. Then they made off with the motorcycle. Therefore, there is no doubt that indeed the accused used violence on the deceased. And so the prosecution has proved beyond reasonable doubt that indeed there was violence used during the robbery, and this has not been refuted by the defense. The third ingredient is that of use of a deadly weapon. The prosecution was further required to prove that immediately before or during, or immediately after the said robbery, the assailants had deadly weapons in their possession.
nti omwalo gavumenti abadde alina okukakasa kkooti ndala kituufu wakati mu kubba oba oluvannyuma nga temunnaba kubba wakati mu kubba n'oluvannyuma lw'okubba mwakozesa ekissi.
Section 286(3)A of the Penal Code Act, as amended in 2007, defines a deadly weapon to include the following.
Nti akatundu 286 ak'ekitabo ky'amateeka nga bwe kyakyusibwa mu 2008 kigamba ekissi nga
that it's an instrument made or adapted for shooting,
kyekintu ekyogi ekiba kikwatiddwa okutta,
stabbing or cutting, and any imitation of such an instrument which, when used for offensive purposes, is likely to cause death.
era ekintu ekyo kyonna bwe kiba kikozeseddwa kiba kisobola okutta.
In his statement, PW3, Detective AIP Kalanga Nusula
nti mu bujulizi bwe omujulizi owokusatu Kalanga Nusula owa poliisi
said he was shown the exact, on reaching Kanisa zone, he was showed the exact place where the border stopped.
nti bwe yatuuka mu kanisa zooni nga muli wamu naye mwamulaga boda weyayimirira.
And that they got off from the motorcycle.
nti ne muvaako ku boda.
Then Mugisha got hold of the rider by the neck,
nti Mugisha n'okwata yali avuga
pulled him down,
n'omusika
and hit him with a 9-9 block on the
n'omusika
head.
n'omuba wansi era n'omuba ebitoffaali ku mutwe.
In the case of Muda C versus Uganda, 1999, 1 East African, page 193,
nti Uganda mu musango ogwa Mudasi nga awabira Uganda 1999 mu kitabo kya East Africa oba kya
pages 193,
ku lupapula 09
even a club was held to be a deadly weapon.
nti ne
A club. Club is a stick with a big head.
nti n'ekiti nakyo kyagambibwa nakyo kisi.
Therefore, in this case, the 9-9 block used by the attackers in accordance section,
etoffaali eryakozesebwa
in accordance with that section 286,
nti ng'osinziira akawaayiro kuno 286
is a deadly weapon and is capable of causing death.
kisi era kiba kireetera omuntu okufa.
Therefore, without doubt, I find that an instrument used by the thugs
nti nga tabuusabuusa asanze nti ekintu ekyakozesebwa
was a 9-9 block,
yali toffaali
which falls within the bracket of a deadly weapon.
erigwa wakati mu kintu kyekisi.
And so the prosecution has proved beyond reasonable doubt that the weapon used was a deadly weapon.
era omwaka gavumenti akakusizza kkooti nga tayaluse mu mulungulu nti ekintu ekyakozesebwa kyali kisi.
We now move to the second count
Tugenze
of murder. Offense of murder, the prosecution should prove the following ingredients beyond reasonable doubt.
nti mu kutta omwaka gavumenti alina okukakasabira kkooti wammanga
As was set out in the case of Uganda vs. Aurian James Peter,
nti nga bwekyali mu musango ogwo gwa Uganda ng'ewaabira
Aurian,
Aurian Peter
that there was the death of a human being which occurred.
nti waaliwo omuntu eyafa.
That the death was caused by some unlawful act.
nti okufa okwo kwaleetebwa ebikolwa ebitali mu mateeka.
That the unlawful act was actuated by malice aforethought.
nti ebikolwa ebitali mu mateeka byali bikozeseddwa mu bigendererwa.
That it was the accused who caused the unlawful
nti
death.
ate mmwe abababiramu mwakola ekintu ekyo.
Now analyze each of the ingredients.
kati kangende mu maaso n'okwogera ku buli katundu.
Death of a human being.
okufa kw'omuntu.
Death may be proved through a post-mortem report.
nti okufa kukakasibwa okuyita mu kukebejjebwa omusawo nga yeekebejja omulambo.
Or witness testimony confirming the existence of a dead body.
oba abantu abalabye omulambo gw'omuntu oyo.
In this case, the prosecution presented a post-mortem report dated 29th of May 2019.
nti mu musango guno omwaka gavumenti yaleese ebbaluwa eva ow'omusawo ng'eriko ennaku z'omwezi 29/5/2019.
Prepared by Dr. Moses Byaruhanga, a forensic pathologist,
ng'era yakolebwa omusawo gwe bayita Moses Byaruhanga nga omusawo ayekebejja emirambo.
who acted at the behest of Detective Corporal Barasa James.
ng'era yakola kino nga alagiddwa
This report was marked as Prosecution Exhibit 1 and was admitted during the preliminary hearing. The body was identified by Detective Constable Nakonde Mariam as that of an unknown individual. Therefore, it is undisputed that the deceased is, in fact, dead. Second ingredient, that the death was caused by an unlawful act. Legally, the killing of a human being by another is presumed unlawful. Unless proved otherwise. In the case of R versus Guzambizi, son of Asonga, it was established that the unlawful nature of the act must be proved. Dr. Birhanga's post-mortem report indicates that the cause of death was brain injury resulting from the blunt head trauma. Consequently, the use of a blunt object, that is the 99 block, on the deceased cannot be characterized as a lawful act. Therefore, the death of the deceased was unlawfully caused. Third ingredient is that of malice aforethought. Malice aforethought is defined under Section 191 of the Penal Code Act as an intention to cause death or knowledge that the act causing death is likely to happen. The question is whether the assailants had intended to cause death or they knew that the actions would likely result in death. And this can be inferred from circumstantial evidence. See case of R versus Tubere, son of Ochen. 1945, volume 12 of Iyaka at page 63. 12. Volume 12 of Iyaka law reports at page 63.
Buli mu kitabo kiri namba 12 ekya East African Court of Appeal.
Yes, at page 63.
Page
given the nature of the weapon used and the targeted area of the victim's body, the prosecution's reliance on the post-mortem report which documented significant brain injuries consistent with an assault suggests that the assault was executed with malice aforethought. Therefore, it's clear that the death was caused with the requisite mental state. We shall now go to the aspect of
Introducing WD Ushers, your premier ushering service for all occasions. From introductions to weddings, birthday parties to graduations, bridal and baby showers, handovers, concerts, vigils and burial ceremonies, we've got you covered. Trust us to make your event unforgettable. Contact us on 0772 411 662 or WhatsApp us on 0705 572 794. WD Ushers, elegance in every step.
It runs across count 1 and count 2 together, the robbery and the murder. The pertinent question, therefore, is whether or not the accused persons or one of them was responsible for the death of the deceased. I find the actions were coordinated. There should be credible, direct or circumstantial evidence placing the accused persons at the scene of the crime as active participants in the commission of the offense. The testimonies in this case clearly rest on both direct and circumstantial evidence. The accused persons A2 Tamalalocious, alias Yangulo, testified that he knew A2 Mugisha before they met in Kampala when he worked as a boda. Along Kafumbe Mukasa Road, while selling produce in Buloba. He said it was not true that they robbed and murdered the unidentified man. But on the day of his arrest on the 19th of July 2019, at 5 p.m. he was in Bukalango, Mwakiso. Seeking treatment from a traditional healer. That for stomach pain. He was arrested in a house by men and women and taken to CPS Kampala, where he spent one day. That he was then taken to an unknown place where his face was covered. He claims he was tortured in that place using a black cable wire, using batons and tear gas spray, and that they had accused him of killing many people and inflicting pain on them. But they later asked him to sign some pages, and he did so under duress. The father said that he did not commit the offense and claimed he was tortured into accepting the charges against him. He asserted that all evidence presented was false. And during cross-examination, he acknowledged his involvement in the robbery at Kakepeka in Mengo. Which involved the robbery of a boda and a murder. And he also admitted that he was a friend of A1 before his arrest in this case. A1 denied committing the offense but confirmed that he knew A2 before his arrest.
Bwe Mugisha wagamba nti tozangako omusango wali omanyi Tamale nga tebanaba bakwata.
As Etu had been his client for some time.
Nti kubanga yali client wo oba yali mu customer wo okumala ebbanga.
He said he was arrested on 14th of July 2019 at Wankulukuku.
Wagamba nti bakukwata nga ennaku z'omwezi 14 ogw'omusanvu ewankulukuku.
And taken directly to Makindye Court,
Nti era ne bakutwala
where he was remanded and taken to prison.
Makindye Court amangu ago bwe bakujja ne bakutwala mu kkomera.
He was later returned to Wankulukuku upon his...
Oluvannyuma baakuzzayo ewankulukuku ku poliisi.
And he was tortured for 21 days before being taken back to Makindye Court and then to Luzira.
Bakubonyabonya okumala ennaku 21 nga tebanaba kukuzzayo e Makindye mu kkooti okutwala e Luzira.
He says charges were not read to him.
Emisango gino tejja kusomebwa.
It was only later given a witness summary and evidence in Luzira
Nti oluvannyuma tibakuwa
in February 2020.
Nti bakuwa ekipapula ekyokwewozaako mu Gwokubiri 2022.
When he came to close examination again, he testified that he was not a friend of Tamale,
Era bwe baddamu okubuuza n'ogamba nti wali tuli mukwano gwa Tamale.
but that he occasionally transported him on his motorcycle about 3 times a week.
Nti naye wamutwalangako ku bodabodayo ng'ennaku 3 mu wiiki.
That would pick him up in Indeba, Kibuli, and take him to Kavume Mukasa, where Etu was dealing in produce.
Nti oluusi wamujjanga mu Ndeeba n'Ekibuli n'omutwala ku Kafundo Mukasa lye yatundiranga ebirime.
So the question is, did they or one of them participate in the robbery and murder?
Court also found that although the accused claimed they were not at the scene when the murder was committed, prosecution witnesses, however, placed them at the scene of crime, supported by their charge and caution statements on the court record.
Court's analysis. The accused persons raised the defense of alibi in this case. However, this defense does not have to be considered in isolation. It must be considered in the light of the totality of the evidence. The defense of alibi naturally dissipates upon adducing the evidence of the identifying witnesses, placing the accused persons at the scene of the crime at the material time. I'll first deal with the law on circumstantial evidence. That circumstantial evidence must be of such a nature that it does not point to anything else other than the guilt of the accused person. Case of Simon Musoke versus Republic. It's also the law. It is also the law that before a court can base a conviction on such evidence, it must be satisfied that there are no coexisting factors tending to weaken or detour the circumstantial evidence. Case of Tepa and the case of Israel Epuku, son of Achetu versus Republic. In the present case, the circumstantial evidence upon which prosecution based this case to connect is that given by PW3, who narrated that Mugisha told her how they hired the boda from Ndeba.
Nti wamugamba Mugisha wagamba omujulizi oyo mwapangisa boda okuva mu Ndeeba.
And told him to take them to Kanisa Zone. That on reaching Kanisa Zone, he showed him the exact place where the boda should stop. Near a gate. And when they stopped, they got off from the motorcycle. Mugisha got hold of the rider by the neck, pulled him down, and hit him with a 9-9 block on the head. And then they rode off on the motorcycle. When asked where he got the block from, he said he got it before the incident. This testimony is corroborated by PW4, who says interacted with her too. And he admitted having committed the 2 offenses with his friend, one Mugisha, alias Kayura. He also narrated how he started doing the job through a friend, one Kazbante. But as they continue having the interactions, they plan to go and rob a motorcycle. And that on the fateful day, he met with Mugisha at Ndemba between 11 p.m. and midnight. That he, Mugisha, stopped a motorcycle which took both of them to Makinde Kanisa Zone. And reaching there, the boda rider was brought down, and they hit him with a 9-9 block. Where they raised the defense of alibi. While an accused does not bear burden to prove his alibi, it's an well-established principle of law that a person who sets up the defense of alibi bears the burden to account for so much of their time during the transaction in question. So as to render it impossible to have committed the imputed act. It also requires that for the defense of alibi to be believed, it should be disclosed at the earliest possible opportunity. I'm aware that by setting up the defense of alibi, the accused does not assume the burden of proving the alibi. The duty still lies on the prosecution to disprove a defense of alibi and place the accused at the scene of crime as the perpetrator of the offense. Case of first Andrew Asenwa and another. Therefore, this court has to determine whether the witnesses were able to identify the accused persons, putting them on the scene of crime. In circumstances of this nature, the court is required to first warn itself of the likely dangers of acting on such evidence, and only do so after being satisfied that correct identification was made, which is free of error or mistake.
nti mu musango guno kkooti erina okuteeka mu nkola okulaba ddala kituufu kuba ekintu kino kyakolebwa mu bugenderevu oba mu ngeri yonna eyasobola okuba nga eraga ddala kituufu nti omusango guno gwazzibwa.
See case of Abdullah bin Wendo versus Republic.
Kyalabikira mu musango gwa Abdullah bin Wendo nga wabeera Republic.
Roria versus Republic.
N'omulala Roria nga wabeera Republic.
And Abdullah Nabulere and 2 others versus Uganda.
Wamu Abdullah Nabulere n'abalala nga bawabeera Uganda.
In doing so, the court considers whether the witness was familiar with the accused.
Ntokola kino kkooti eteeka mu nkola okulaba ddala kituufu oba abajulizi bano baali bamanyi
whether there was light to aid visual identification.
nti oba waaliwo ekiro oba ddala basobola okubalaba.
The length of time taken by the witness to observe and identify the accused.
Nti ebbanga erimaze eriyitawo ng'omujulizi oyo
And the proximity of the witnesses to the accused at the time of observing the accused.
Nti n'engeri omujulizi alina gy'asobola okubeekenneenyamu oba okubategeeramu.
On the issue of familiarity, PW6 Bureau Justice ASP testified he knew the accused persons, as they had been suspects on several cases before.
Nti mu kyokuba nga mutegeerekeka oba mumanyika nti omujulizi ow'omukaaga yagamba kkooti nti yali abamanyi mwembi nti era mwali mwenyigira mu misango egy'enjawulo.
That is from 2017 to 2019.
Nti okuva nga ennaku mu mwaka 2017 okutuusa mu 2019.
When they escaped from prison.
Nti bwe mwadduka okuva mu kkomera.
On that day, they also escaped from Kiranda Police Post under Kaboa. On 17th July 2017, when he was arresting Mugisha Bosco, he got information that he was on the wanted list since he had broken off from the cells. On the length of time taken by the witness to observe and identify the accused and the proximity of the witnesses to the accused at the time of observing the accused, he testified that initially he was in the case of escaping from lawful custody. But reaching the post, he got a phone call that there was a video circulating and that Mugisha, whom he had arrested, was on that video. So the way he was dressed the day he was arrested, and it was the very way he was dressed in the video. He also recognized Mugisha hitting a person several times and both of them falling down with a motorcycle. And while down, there was a scuffle within them. When he asked Mugisha whether he was the one in the video, he told him he had hit several people more than this. He further recognized that the short one was Mugisha, John, while Tamaloshia's last young Mulo is the taller one. Therefore, A1 was recognized by PW6 and placed at the scene of crime as per the evidence of prosecuting witnesses. May I say that you were identified, unknown to you, the gate where you asked the man to stop and where you robbed his motorcycle from and hit him on the head, with several injuries on the head at Kanisa Zone, had a camera. And that footage from the camera was the one which was circulated, and it showed that you came and got out of the motorcycle, fell down together with the guy, you put the guy down, and then began having a scuffle with him down and hitting him on his head several times with a stone, and eventually died.
Justice Alex Ajej further found that it was John Bosco Mugisha who pulled the deceased Derek Muwonge off his boda before they murdered him, stole the motorcycle, and later sold it for 600,000 Ugandan shillings.
Further on this issue of participation with common intention, Section 20 of the Penal Code Act provides as follows. Section 20 of the Penal Code Act provides as follows. That when two or more persons form a common intention to prosecute an unlawful purpose, in conjunction with one another, and in the prosecution of that purpose, an offense is committed of such a nature that its commission was a probable consequence of the prosecution of that purpose, each of them is deemed to have committed the offense. Under Section 19 of the Penal Code Act, there are different modes of participation in crime. There are direct perpetrators, joint perpetrators under a common concerted plan. There are accessories before the offense, etc. Each of the modes of participation may independently give rise to criminal responsibility. If the accused was unaware of the criminal intent of the mob and he gave it substantial assistance or encouragement in the commission of the crime, then he was only an aider and an abettor. But if he shared the intent of the mob, then he is criminally responsible, both as a co-perpetrator and as an aider and an abettor. So it has been shown in this case that both of you participated in this offense. PW7 Tenure Ronda testified while previously at Katwe Police that while previously at Katwe Police at the time of the case in 2019, he was the investigating officer.
Police station
And during his investigation, Mugisha was arrested. He described, A1 described how they did it and mentioned about the concrete block which was used. He also described how he hit the victim and they made off with his motorcycle. But they revealed that he was with A2 on that day, where they removed the motorcycle from the victim and sped off with his motorcycle. According to him, that you told him that the role Tamale played was to strangle the victim very hard, and they fell down. But that it was you, Mugisha, who reached for a half brick and hit the victim. Hence this case of CRB 904 2019, robbery and murder. And in the processes,
nti gwe nga bagenda maaso n'okubuuza bagamba nti gwe omu ne Tamale mwali mwenyigidde mu misango egy'enjawulo mingi egy'okubba bodaboda nti era wakati mugenda maaso n'okubba.
And that you, Mugisha, led the police to various points where you were hitting bodabodas and stealing their motorcycles. And that's how you even led them to Kanisa Zone, where the victim in this case was murdered. During cross-examination, you said you sold the motorcycle and you got 600,000. During cross-examination, you testified that the stone was a rough object where fingerprints could not be lifted. You testified that you knew each other. So in order to make the doctrine of commutation applicable, it must be shown that the accused person had shared with the actual perpetrator of the crime a common intention to pursue a specific unlawful purpose which led to the commission of the offense.
Wakati mu kugenda mu maaso n'okukakasa ddala kituufu mwalina ekigendererwa ekyokukola omusango mwembi babiri ko terina kikakasa ddala kituufu nti mwembi mwali mwemanya ate nga mulina ekigendererwa ekyokubanga muta.
Communication may be inferred from the presence of the accused persons.
Nti kino kiyinza okulabikira mu ndabika yammwe oba mu buliwo bwammwe,
their actions,
ebikolwa byammwe,
and the omission of any of them to dissociate himself from the assault.
Nti neeyisa eri ku kinoomu okubanga mweggyako ebikolwa ebyo oba nga mubikola.
In the circumstances of this case, we consider that there was a clear intention by the accused persons to commit the offense of murder and aggravated robbery.
Nti mu musango guno tukisanze nti waliwo ekigendererwa mwena kyemwali munekyawamu ekyokukola emisango gino ogw'okubba wamu n'obutto.
Has destroyed the alibi.
Nti n'olwekyo obujulizi bwe oba okwewozaako kwe mwagamba nti temwaliwo ng'omusango guzzibwa, atusanze nti omuwala gavumenti yakiggyeewo olw'obujulizi bwe yaleeta.
In the case of First and Roa Senwa and another was Uganda,
musango gwa First and Roa Senwa wamu n'abalala nga bawabira Uganda,
the Supreme Court held that, among other things, if an accused person does not bring forward the defense of alibi until months afterwards, until months thereafterwards, there is naturally a doubt as to whether he or she has not been preparing it in that interval. Therefore, be that as it may, the prosecution had used sufficient evidence discrediting their defense of alibi raised by the accused persons. However, from the prosecution evidence, I note that the accused persons were properly identified by the prosecution witnesses. All had communication to commit aggravated robbery and murder. I find that this element too has been proved beyond reasonable doubt. I find that the accused persons are guilty of both counts of aggravated robbery according to section 285 and 2862 of the Penal Code Act, and murder according to section 188 and 189 of the Penal Code Act.
ekikontana n'akatundu 285 286 ak'ekitabo ky'amateeka ekifuga emisango egy'amaanyi.
I so order.
Ambatse yali mu musango guno yatagenda mu maaso nagwo asaba kooti evvoyo obudde eyagulimu ajje agende mu maaso nagwo.
We'll give it another day for Qatar. This is August.
On this and other grounds, Judge Alex Ajij found that two guilty of murdering Derrick Muhonge. After the judgment was delivered, convict Alex Arogias expressed dissatisfaction with court's decision. Judge Alex Ajij, however, responded to his concerns.
I humbly request to talk to court.
Yes, please.
I pray that the case where I'm convicted, the offenses where I'm convicted, I do not defend myself because I provided to court that the defense in written. But God has not considered my written defense and has not put it into consideration.
Court has not?
Has not considered my defense and has not put it.
Where do you get that? Did I say there's a sentence in my judgment where it says both parties tendered in submissions and I have considered them. God can consider them, but if there's nothing important that's worth, then you don't expect a mention of it. So, further not
I want to bring it attention of this honorable court that the way I've been disturbed in this court. I've been complaining. But you've always told me that my state is not allowed, that I should leave it. But at the beginning of this case, that at the beginning I was prevented from speaking, and you just told me that I would put my defense in submission.
Even your lawyer gave his information. What I've heard being read that is that when the case was that during the commission of the offense I wasn't present. But in my defense, I showed that all the statements were made before I was arrested. And I showed that in the record of proceedings when the witnesses were talking about it. That I don't know when the offense was committed, that day when the offense was committed and I wasn't present, and they just informed me that I committed an offense. So that I request court to consider that all the statements that
zakolebwa nga sinnakwatibwa.
The said statements were made before I was arrested.
Okay, thank you.
Ddala PF24 yakolebwa kuli date and time arrested Tamara Rosias.
Especially PF25 was done when Tamara Rosias was being arrested.
But let me say two things. One, in good faith, that get a chance to discuss with your lawyer, Richard Kumbuga, and raise those concerns and see.
Introducing WD Ushers, your premier ushering service for all occasions. From introductions to weddings, birthday parties to graduations, bridal and baby showers, handovers, concerts, vigils and burial ceremonies, we've got you covered. Trust us to make your event unforgettable. Contact us on 0772 411 662 or WhatsApp us on 0705 572 794. WD Ushers, elegance in every step.
If he will uphold your concerns. Number two, you say you are not around. You know to do things. But court relied on evidence that was available to the effect that one, you made a charge and caution statement. Police officers came here. Testified the charge and caution statement. It's also on record that you denied having committed the offense. And it was the duty of the prosecution to put here the scene of crime. Which in my view, in court's view, was accomplished by the prosecution. And also more so using your own charge and caution statement. It's also in evidence that you had committed several other offenses. That you are actually, it's also on record that you are actually convicts. It's also on record that you there was a video which did its rounds showing you in action. So court considered all that, the circumstances, and the fact that the police also said you had been people escaping from lawful custody several times. And you know that, Tamari, by then you were young people. So you were really very, very skillful and capable of doing whatever you did. Now you have grown, now you are men. You appreciate you are now actually men. But give yourself your background and reflect on it yourself and say, how was I living my life at that time? Was I a good boy? Were we good boys? Well, how is it that I am not being got guilty in this case, guilty in the other case, guilty in the other? How is it that I appeared in various police stations? And ask yourself in your eye, which is in your heart. Look yourself in yourself and say, how many people did I kill? How many people did I kill?
nti bantu bameka be
Show that
n'akatta
my God.
nti ngeri
Talk to
katonda
your
wange
God. Talk to your God and see if it's not
yogera ne
true.
katonda wo bwekibanga si kituufu
God will still deal with it. If
katonda
it is true,
takikolako
bring yourself before God.
bwekibanga kituufu wetwale mu maaso ga katonda
Wekitiibwa omulamuzi.
But you have a right of appeal against
naye
the
olina
decision.
eddembe erikuweebwa ssemateeka eryokugenda kujulira
Ekyo kituufu.
And I really give you the chance to
Need
appeal.
justice.
nti era kuwa oddembe okugenda mu maaso n'okujulira
When I do my things, I do it in the name of God.
nti bw'akola ebintu bye abikolera mu linnya lya katonda
Even before I came back today, I came here this morning.
nti ng'era tanaakujja
Enter that court.
nga tanaakujja kuyingira kooti eyo
I called upon my God to be with me
yayise katonda we okubeera wamu naye
and asked Him to be with me
era n'amugamba
for me
abeere
to do the
naye
right thing
akole ekintu ekituufu
on the job He has given me to
ku
do.
mulimu gw'amuwadde okukola
That as I sit in His chair,
nti ng'atuula mu ntebe ye
which is a chair of justice,
entebe
may I
y'obulamuzi
administer justice.
asobole okuwa obulamuzi obutuufu oba
It is my sincere belief
nti akkiriza mu mutima gwe
that I've done justice in your case.
nti era akoze
The justice which comes from
mu
none
musango gwo
other than from the Almighty God.
nti amazima agatava wantu wona naye eri katonda oyo gwakkiriza
And trust.
era gwe yeesiga
So indeed, if you are not satisfied,
nti era bw'oba toli mumativu
I shall really call upon you to first of all sit down and reflect.
nti akusaba ekisooka ofule wansi weekube mu mutima
Once convinced and convicted that you must appeal,
nti bw'obanga okukakasiza ddala nti olina okujulira
to Kumbuga Richard,
olina eddembe okugaana looya w'okumbuga Richard
you should surely be able to help you
nti era ajja kukuyamba
towards that end.
okukola ekintu ekyo
Bange ndi musajja atya Katonda. Era ngeno okutte Bayibuli. Yes. Yes, owekitiibwa omulamuzi. Omusango bagamba gwe nalabikira mu Katanga.
eyo byapiru ssebo
Bwe guli omusango gwe nakkiriza naye ate mpulira bakitadde funa omusango nti gwe nalabikira mu Katanga. So kyola n'agambye nti nyatangaza kooti.
If you were a first offender, it would be very easy to believe you.
singa obadde nga wakaza omusango omulundi ogusooka talibadde kyangu nnyo okukukkiriza
But now you already have about 70 years,
naye olina emisango
different cases.
olina emyaka nga nsanvu egyogenda mu maaso okubeera
It becomes
mukolera
very difficult to
mu
believe
misango
you.
egy'enjawulo kijja kuba kizibu nnyo okukkiriza
But think of, if you're a Christian, think of that using that Bible properly.
bw'oba nga oli mukristaayo lowooza ku kusoma ekitabo ekyo kya bayibuli bulungi
Thank you.
Wajukadde ne basi nduze sabo bwentanda.
Kuba sitegedde bulungi. Kanso. Twakugira mukono.
In a separate development, Judge David Matov of High Court Criminal Division has adjourned the hearing of the murder case of Ndiga clan head Engineer Daniel Bosa Ruhoma on 13th August 2026, following the absence of some of the accused lawyers in court.
This court will take plea on the 13th of August 2026 when A3 and A5 have got state brief lawyers appointed for them. Those persisted they get lawyers, A3 and A5. On that day, I expect Mr. Walusa Sambaga, counsel for A4. Mr. Nakawari, tell your lawyer to be in court on the 13th. You're remanded until that date.
Introducing WD Ushers, your premier ushering service for all occasions. From introductions to weddings, birthday parties to graduations, bridal and baby showers, handovers, concerts, vigils and burial ceremonies, we've got you covered. Trust us to make your event unforgettable. Contact us on 0772 411 662 or WhatsApp us on 0705 572 794. WD Ushers, elegance in every step.